What's going on?
Well,
Let's do 4 and 5.
Oh, for the minor point, the video, he's talking about some email back and forth. I was concerned that he used the video for purposes unrelated to the case. At the beginning of the deposition, I said, are you going to use this for purposes unrelated to the case? He said, no, I'm only going to use it to check. And therefore, I didn't have any further objections. If I had further objections at that time, he said, yes, I'm going to send it, post this on my Facebook page, and I'm going to send it to the newspapers so that we can trash your client or cut it to use commercials, which he did not say on the record. I would have initiated a phone call to Bill Richter and explained that we had an issue. You know, so the fact that we had some communication back and forth is kind of irrelevant in emotion, but that's the genesis. The fifth one, he's saying that well, I think you can sort of address this. No motion to quash. There were 3 different motions. One notice of the deposition. One I think was even the night before the deposition. I mean, he can make motions and make arguments faster than I can respond. It's kind of like trying to do it, get a fist fight with a room full of gnats. It's not going to work out well. But I didn't see any reason to spend more of my client's money on a motion, filing a motion to quash when we didn't have a right to do it to begin with. And I understand your concern about this. By the way, not all courts will say that an affidavit has anything to do with waiver. You know, I understand the argument being, but it certainly doesn't have anything to do with it if it's not part of the case. In chief deputy. And therefore, since we have waived nothing, certainly not freely and voluntarily, under the rules that are coercive at the preliminary hearing stage, and since we are presenting nothing to waive anything at the hearing in our exhibits, I respectfully suggest that my client has the right to insist upon the rights that are guaranteed both by the rules of the commission and by Article 1, Section 10 of Ohio's Constitution, not just at all, unless and until the chief.
Am I allowed to respond? 2 minutes.
You know what, I'm going to allow for your 2 minutes, please keep it 2 minutes.
But it doesn't start until I get it.
159.
By the way, I just want to correct some things. He mentioned the deposition, the day before. The deposition the day before he talked about it, I had to move the address by 1 block. So he's referring to something because I had an issue with the room it was going to be in, so we moved it 1 block down the street. That's what he's talking about. Again, I think that all this is, to me, a little bit ridiculous. Well, how am I going to find it? Is because I'm asking very pretty simple things. If he wants to respond to the interrogatories and say object to every question and notarize it, send it in, okay. If he wants to, as a witness, assert his Fifth Amendment right of self-incrimination under oath, okay. I don't have any problem with that. It's fine if he does that. The thing here is this constant rope-a-dope that I think is being pointed out where we constantly are going through these things. So I just come back to my points before my time expires is I think Alan Freeman, if he should have to be a witness and take an oath, and he can then assert his Fifth Amendment right of self-incrimination at that point in time. I think he should file a proper response to the interrogatories. And I would say he did agree to this. His counsel did agree to this, and all that 2 hours of he provided the template. As I will put somebody's point out, he provided the template for me to use to put him into. And the deposition thing, I still think, I know somebody said I shouldn't, but or they get canceled all the time, is that he should have filed a motion to quash the deposition. He can't just send threatening emails about depositions and not file a motion. I repeatedly counsel him file a motion, and then I'll put it on hold. But he wouldn't file a motion to quash the deposition because he didn't want it to be visible to the overall commission of what was going on basically Alan Freeman trying to avoid anything under oath, except for that he has a affidavit that he filed that apparently for some whatever reason can't be questioned or brought up, which to me seems ludicrous. If that's the way the law is, then the law needs to get changed. But thank you guys. We're done with those 2 minutes.
Okay, at this point, again, we have 3 motions before us. what I was gonna say or the question. This is go. Or discussion regarding the three motion. Go ahead, question.
I just want to add, I said, can I have Mr. Richter a question? So I'm sorry about that.
Okay, Jake. Yes. Aaron, go ahead.
So, do you agree with Mr. Bryd's position that under the case law and constitution of the state of Ohio, that when you're a respondent, the proceedings before us, that it is a criminal proceeding, that you have the, whether it's civil or criminal, you always have the right to vote. But that as the respondent, it is a criminal proceeding against him where one of the potential penalties through referral to prosecution would be deprivation of liberty.
Yes. Simply stated, yes. I mean, obviously, we are acting in an administrative capacity as an administrative agency, but the statutes that we are responsible for are essentially criminal statutes. And anyone before this commission is potentially facing criminal prosecution, depending on what the commission does. And so this commission has always acknowledged that approach and given the respondents the ability to act as Mr. Bride has laid out, in respect of the fact that, yeah, this, ours, we invoke the civil rules. Yes, we are an administrative agency, but at their base, the statutes the commission enforces are criminal statutes, and we always respect them. At least, as Mr. Bride kind of pointed out in his statement about him being the first one to invoke the road situation, which I think was back in the 80s. Since this commission has been an independent agency, at least we have always accepted the fact that a respondent has the ability to essentially defer in respect of the fact that there are criminal statutes in there.
And do we require, historically, have we required a defendant or a respondent in any circumstance where they're taking it to person here to get, to file something in writing, or can they do it through their counsel?
We have not had that. Generally speaking, I would say that what we have done is just acknowledge that that is the case and allow that to occur and not necessarily, obligated the respondent to make any kind of a statement or other presentation. Counsel has generally invoked that because in situations were different. In this one, it's been a situation, and it primarily occurred in false statement cases where someone was represented and their counsel more or less spoke on their behalf to the commission, reflecting that, they weren't going to testify. Or in some cases, they allowed the client to go ahead and testify, even though they were facing potential criminal sanction. Because generally speaking, the commission was going to refer a false statement case for prosecution, and they just dealt with it. I'll also, just add kind of as a side note to Mr. Rice's comment about, the obligation in our statute, wrote the rule all those years ago, realized what I was doing in writing the rule, and acknowledge, his consternation that it causes. But as you can see from when we deal with group matters, and even like the disclaimer case before this one, it helps this commission deal with them for a majority of cases, and unfortunately can come into a situation like this where it causes the respondent a bit more consternation, let's say, when they're faced with having to put in some sort of a response.
That one final
or intentions.
in this case, prior to the answering of the interrogatories, was there any occasion where Mr. Freeman had invoked the fifth prior to that time?
Including when he submitted his affidavit.
That's what my question was. Prior to that
So
time, did we know? Have we ever been? did
I am
we
not
ever-
recalling again here,
I don't recall it.
I am not recalling, yeah.
And my question goes one step further, is as it relates to submitting an affidavit before this commission, does that not waive the witness's ability to invoke the fifth as it relates to those items contained within that affidavit?
We haven't, what I could, how I will respond is that is not an issue that we have really more fully delved into. I think that it is certainly possible as it relates to those particular statements. You could make that argument, but, considering, as Mr. Bryce has phrased it this afternoon, the coercive nature of that can certainly be something that could be used to defend the fact that those statements were submitted.
Well, it also lets you testify in an unbodied.
I guess I would answer that essentially, yeah. This is one of the rare cases where that has come into play.
I've seen it.
Yeah, and so I can go back 25 years. It may have been raised in the past, but I am certainly not specifically recalling any instance of that being the case. So I can't draw on any previous experience of the commission and say, yeah, this is what we've done under those circumstances.
So we're taking the view of the statement, the representation or the set of facts that's put out there, the word, not the subject matter area. That's that statement. As far as
I'm sorry, say it again.
I didn't quite catch it.
Yeah.
wow.
I think it was.
I'm right there with you, honest. This commission, I guess, maybe I'm answering, this commission has always respected a respondent's ability to not participate in a case against him because of the fact that the statutes that we are enforcing are civil criminal. Is that answering your question?
In the past, when I've done it from a civil standpoint, if I had concern with my client testifying and potentially self-incriminating, I advise them not to answer any questions to avoid any potential waiver. In this particular case, that's why I'm having a difficulty because we have an affidavit where there's sworn testimony in this particular case. That's the problem I'm having.
Phil, question. Looking at 3517-104, the response. I mean, the language is clear and unambiguous. It says if the respondent fails to file a proper response, and I'm not going to read the thing that goes on, the respondent may be deemed to have admitted the allegations in the complaint and may allow the commission to make a finding against the respondent. Clear, unambiguous. It doesn't go on to say that in lieu of that, you may invoke your Fifth Amendment rights. It doesn't say that you may jeopardize yourself by not being able to invoke the Fifth Amendment. It says quite clearly that your case might be lost if you don't respond. Have we ever forced somebody who did fill that affidavit out to testify anyway?
It's certainly possible that that has occurred, but I am not recalling a specific instance of that. And like I said, it is a very rare occurrence that a situation like this has arisen where you would have seen something like that. And so that's one of the reasons why I'm not recalling. I can't say it has never occurred, primarily because I'm not recalling if it has.
And I'm trying to call from the back of my mind whether it's specifically called out in the civil litigation.
I guess my question is, how do you stand on both sides of the line?
I think if you're going to invoke it, you can. My perspective is if you believe that that's unconstitutional and it's going to adversely affect your client's constitutional rights, from my perspective, you raise it then. It becomes an issue at the preliminary hearing. You say you can't hold it against me, you file an objection, and you call the question. And that, it doesn't have to specifically say in our rule, if you think it's unconstitutional, challenge now. That would be, I think, to the Commissioner Kaufman's point, that's the can't stand on both sides of the fence. Now, does that mean it's a blanket waiver? Probably not. I'm not even suggesting about the waivers point. I think at this point in time, we're just talking about motion to quash or whether we're in a criminal proceeding and whether somebody can invoke their rights. If we get down to the issue of did they waive it? I mean, we would have to give the parties the opportunity to respond to that issue. It's sort of a new issue, and then maybe some legal research involved. And to give both parties appropriate time, I think we would have to let them address that. But that is, from my perspective, that is a question, which is kind of why I was asking Mr. Richter, was it raised? And to Mr. Norman's point, should it have been? And from, I think, from my view as a commissioner, when we were talking about discovery, if that was a position, I would have liked to have heard it at that point in time, because it was not excluding our expectation that that was going to be our person.
I guess, I don't know, I see your point, but, and you're saying should it be raised? And I guess my question is, does it have to be?
You're going to claim that it does.
Sure, it does.
You raise or waive. That's the way that lawyers work is you raise it or you waive it. So if you didn't raise it, you waive it.
You can't put out testimony and say, oh, I want to pull that back.
Even in the face of clear and unambiguous language that requires you to fill out an affidavit or suffer the loss of your case. I'm just asking, I don't know.
I mean, it's not saying you're for sure going to lose your case, it's just saying you're putting yourself at jeopardy. Which I think anytime you're in a situation of being in front of a commission or the court or whatever, no matter what you do, you're, only one person's gonna come out,
It reminds me of the movie Monsters Inc. Don't open the door if you don't want to see what's behind it.
Oh, go ahead.
If the issue which is that they have further briefing decided they could do. A waiver must be knowing and voluntary. There was no knowing and voluntary waiver given the language of the agreement. And there was more than wrong to read that, maybe get some cases, when the question was asked, does this constitute a waiver? Okay, good, if that makes it good, they fully does either any of the motions related to this issue.
Well, I'm fearful that this is going to set precedent one way or the other. And I think in my mind, I'd rather have maybe the advisory opinion as to that decision opposed to us just making the decision here without really, if I have a reason, I just go based upon my practice in past.
I'd like to make a comment because I was patiently raising my hand and let me get up, give a comment without
I'm sorry, I don't see.
doing that. So, all I'm asking is that he in some form take the fifth under oath. And that's all I have asked, okay? And I don't think Mr. Richter referred to criminal. I'm not a lawyer. You guys don't have any ability to assess a misdemeanor or a felony on anybody. You have the ability to fine them. If it's going to be criminal, where there could actually be a criminal finding of misdemeanor or felony, you have to do a prosecutorial referral to make that happen. So I think in this body, you're mostly civil rules, and there's a fine implication, and he can claim the fifth under oath. But it's, again, a lot of the shield and sword stuff. We want to use things both ways. When we're standing here, we want to talk on a call like we're going to negotiate an order we have no intent to respond to it. So I think, and so I think, I think it would set horrific precedent that that's the two sides of the line thing here. And again, I apologize, because I'm a little able-minded right now. But the whole notion, you can't find somebody who committed a misdemeanor or a felony. Okay, you can find them, and then you can refer them for prosecution. So to conflate that this is because the statutes have a potential for being criminally referred, that means that we can just shield and sword, lawyers like Don Bray can decide when we're going to do things or not under the civil process. Sometimes I like the civil process, sometimes I don't. I think they're problematic for this commission.
Mr. Ricky, what would your recommendation be?
My recommendation would be to deny the motion to Mr. Hicks, And while
We're not talking about my motion.
Yes,
It is.
and while I will go back to the reason why I issued, certainly Mr. Hicks, requests the subpoenas, and I use subpoenas as it relates to both Mr. Amos, didn't got anything yet, but, the primary reason why I did that, is, I kept recalling circumstances in the past when this commission, has had, let's say, one party show up at a hearing and another party not. The question from commission members was, well, did you subpoena that person? And the other party said, no, I didn't. And the person didn't. Sorry, we made that on that too. So that immediately realizing that, it's certainly possible that, Mr. Freeman and his wife would, could, in my opinion, cannot be compelled to testify. Again, because with all due respect to Mr. Hicks' assertion, the statutes that we are enforcing are criminal statutes. I wanted to make sure that they were at least in attendance based on his request to have them attend, and if they didn't testify at the hearing, so yeah, that's the choice that Mr. Freeman, Mrs. Freeman, and Mr. Fry would have to make. But I wanted to issue subpoenas for those reasons to ensure that they were present. And primarily Mr. Freeman, because he wasn't responding. That makes me kind of know if I'm stumbling off myself, but yeah, so I would grant Mr., as long as Mr. Bry agrees to, the presence of Mr. Freeman and Mrs. Freeman, for the matter, getting ahead on that one, that they will attend, I would move to, approve his motion to quash and again, overrule or deny Mr. Hicks' motions to both compel Mr. Freeman and also as it relates to sanction. There's my long-winded response.
I stumble because I still think, based upon the fact that he submitted the affidavit, that there should be, and maybe I'm wrong, but there should be allowed testimony as it relates to that affidavit. Because he submitted to this commission, he didn't object to it, he didn't, invoke his Fifth Amendment rights, he said, here's my affidavit, here's what I swear to. And I guess maybe what I don't know if I want to put forward and say I'm willing to move the motion to compel forward, but I'm thinking maybe we need to do a little more research to to make sure that what I'm thinking is the correct path. I'd be interested in from anybody else in the commission about their thoughts. I'm a lone wolf.
I don't know, or at this point, I don't even know, or at this point, are we just talking about the motion that quashed the subpoena from Mr. Freeman? Is that what you're talking about?
That's what I'm talking about.
I'm not sure what you're talking about, you seem to be talking about everything.
Or we had.
Well,
no,
what's happening?
I did kind of include Mrs. when I shouldn't have, but we were talking about the motion to quash by Mr. Rod, and the motion for.
The interrogatories.
Right, to compel as related to interrogatories and the motion regarding the sanction.
Really, all relating to Mr. Freeman.
That.
We're talking about three things about Mr. Freeman at this moment.
Correct.
Okay.
That was the whole presentation by both gentlemen, so.
All right,
And the
that's
back
right.
and forth.
As it relates to production of documents, you've got those, correct? So we're really talking about interrogatories and we're talking about deposition testimony as it relates to Mr. Freeman.
Right. Again, I'll go back to my recommendation would be to deny those motions. I'll keep it simple.
Deny all three?
No, hey, now you're moving, like I said, as it relates to Mr. Hicks' motion, my recommendation is no.
Can I,
That's all. I'm saying.
So, you got it, yeah.
well, related to the document discovery, I think I have the right to have Mr. Freeman authenticate that discovery.
And then authenticating.
He did not notarize it.
I've only been on this commission for 5 years and never required anybody to authenticate it up.
I'm good with that being the rule of the hearing.
I mean, I'm assuming we get Mr. White to stipulate that from this.
We have little numbers to the lower right. If they're the numbers we gave, they're the documents we produced.
Thank you.
Any other discussion? Let me just ask this one question. So, Commissioner Norman, is it your position that until we resolve this, issue of the waiver, related to the affidavit, that not move forward, motion to block, or fell, and motion has been sanctioned? If I understand that correctly.
I don't think it has anything to do with the sanctions. That's a separate issue. As it relates to the others, yes, I think that is, I would agree with that. And I'm not saying that Mr. Freeman has opened himself up to testimony in general because he gave his affidavit. He has to provide a deposition unbridled, but as it relates to the affidavit, since it's been submitted, it was sworn to and attested to and submitted to our commission, I believe he has opened himself up to cross-examination as it relates to that testimony.
Okay, and then if that's it, for the sake of time, please speak with, Mrs. Freeman. Okay, with the similar motion. Is there an affidavit for Mrs. Freeman?
No,
Okay, so affidavit.
Can we say them one at a time?
Well, no, I agree with you. There's different issues.
Okay, I want to make sure we're a different issue.
So, given that, we could. Just thinking out loud, not making a suggestion.
Or a motion?
Or a motion. If we deny the motion to quash as it relates to the attendance of the hearing, that certainly, to me, would not that certainly would not, you could still complete the make the same objections, it would force the issue, we could allow a completing decision at the hearing. It's one avenue, we could go to conference court, I suppose. If we deny it, I don't know if that's an interlocutory order or not, so whether that would even be an option. So that's one thought. Another thought would be to just grant the motion of quash and recognize the Fifth Amendment right without any formal filing or testimony or hearing on that witness. What are there other options?
we can hold out advance and do some further research as to the issue, just really see if you stand or do wrong or no.
And do we proceed with the hearing in 2 weeks anyway? Leave the parties in abeyance on that?
If we take the stance that we're going to research the issue, I don't see how we move forward at the hearing on the 26th. If we make a decision one way or the other as it comes to granting or denying emotions, then I think we can still move forward.
I'm interested in other commissioner members.
Well, I like the idea of getting additional information. Concerned about setting a precedent, certainly, and so if we're going to accept one, we should have as much information as possible.
And a feeling about going forward on the hearing.
I'm not sure we're going to have the information by the time of the hearing.
Well, let's assume we have the research information. We're not going to then have a formal decision on the motion before that hearing, which means if we agree that Mr. Hicks is entitled to discovery, he's not going to have it before the 26th. So if we go forward and say that as a commission, we decide we want more information, we want to give, whether it be an advisory opinion or make a decision, I don't see how the hearing on the 26th proceeds.
Mr. Richter, if we continue the hearing, can you tell us what soonest available date is given?
Oh, I get it. Under that. Pam Freeman and Susan Jones issue are separate, and we can move on these motions today. Would they be able to get part of the hearing?
Well, Susan Jones are gonna be deposed at 3 o'clock today, so that's gonna be a transcript. So
We got the huge sheet too.
Or if we change the hearing date, maybe we
If we
could
take
call
the
it.
hearing date,
Yeah.
that the rock
They don't
with
need
Susan
that.
Jones, which I would totally agree with. If we want to push, if you want to get more information, push the hearing out, make it this, I think it is a great, very important distinctions here that are coming into play. And there's no rush to have the hearing. The events that we're talking about already happened. They're not a fluid, it's not a progressing crime taking place. And so I'd be all for delaying it, and then we don't have to we can figure out a better time for Ms. Jones to either be deposed or she can appear at a future hearing date, because now we eliminate some of those issues. I totally agree with you. If you look at all this stuff, and we're doing 7 things right now. We've got, as my grandmother used to say, we're trying to put 10 pounds of sugar in a 5-pound sack. And there's so many things still up in play in this case that I think deferring the hearing longer so you guys can do more research would be fantastic.
What's the status of Ms. Jones?
Well, I don't know where the calendar is. I think it might make sense to see if obviously my preference is to grant my knowledge in United. I'm not sure that's going to happen, but if the commission decides, overnight, to continue the hearing, she may be able to be here. You know, the issue is not that she's not going to ever show up to the commission's hearings. So it may make sense to delay the deposition date until we determine whether or not she's able to do that. And then if she's not, you know, we can find time for him to do a testamentary deposition.
It's worth mentioning, there's also a series of, I think, I don't have it in front of me here, but 5 or 6 subpoenas, witness subpoenas that have not been served at this point. So that's another issue that's pending on the 26th. And some of those may provide, like Ms. Pinkin, having a number here that wants to talk to me about how she's going to respond if she's not following motion to quash. I just think you're going to need another meeting because there's going to be other witnesses that file motions to quash. And you're going to need to be able to hear those once they come in, but they haven't been served yet. So, like maybe a third to half of the witness subpoenas haven't even been served at this point.
So, Mr. Richter, what are our September dates?
September 9th, September 23, October 7, and October 28 are the current dates. December 2nd, December 18th, the rest of the, and 2022.
I think in fairness to Mr. Richter, because he's been the one who's going to be getting some research directed to him, I think we should maybe look at the October dates. Maybe my suggestion would be is that we continue it. We have Mr. Hicks and Mr. Bry confirm their witnesses and their availability for the dates in October. Anybody else have any thoughts?
I would sort of lean toward the earlier dates because the way this case is going. I would like to think that we actually have a date that is scheduled for, but it'll just maybe.
Here's what I'm thinking is that October 26th of their next meeting puts us out 2 weeks. On the Tuesday, but if we give the parties 2 weeks to respond, that puts us just at an experience before we're even getting who's Richter reviewing and then providing an opinion. That's why I was thinking October.
Should be all right if the already scheduled is well in advance.
Right, exactly. Both parties, or you can't be there.
What were the 2 dates in October? Or you guys?
7 to 28,
I better look at my calendar before
October 7, October 28, sorry.
The last 2 pieces, or the last 2, pieces that we received were on 7. And so I'll just throwing that out there shows you the kind of timing.
While we have a November date, I wouldn't suggest going that far at this point for other reasons.
For my calendar, the earlier October date would be fine. I would prefer not the later October date because it's totally unrelated to this matter. I'm involved with some candidates locally, and that's right before the election. And that's a lot of stuff going on.
Oh, that's good.
But I don't, beyond that, I'll be as flexible as possible on whatever date you guys want to have. But
I personally don't have any conflicts with either. I'll check with Alan Freeman, but it's very easy to get it done.
I have a trial that is set, actually, two trials set for the fifth. But the odds of them going probably aren't very good, so if I have to tell the judge I need to have a day off in the middle of the trial, I'll do that. So I can make the 7th, 28th is better, but I got a motion, I guess.
As long as it doesn't go real long on the 28th, I'm okay.
And what about the seventh?
That is fine, that is fine.
Just
I
as a
think-
parent, I question my schedule is 28 of October.
Right.
So I think that's a problematic thing for me, so I would prefer that either October 7th or do it beginning of their first meeting in November. Even.
I move that we hold the motions that are currently pending in this matter in advance for further research submitted by the parties by August 26th, which is our next scheduled hearing date. I move that we move the August 26th hearing that is now scheduled to October the 7th.
You heard the motion? Second.
I have a question.
Okay, good. So it's
Is it your thought? Speaking on that, we're gonna rule on the motions on the 26th?
My thought was that the party would submit the memorandum by the 26th to Mr. Whitburn
On which motion?
as it relates to the issue of waiver and the testimony as a potential waiver.
Okay,
We don't need anything else on any other motion. You've got all that. But we're gonna stay and ruling on the motion, so it's next time you did this, it's not research. And you would, I presume, would be an advisory opinion from him or a memorandum.
Probably a memorandum, I mean, an advisory opinion is something that the commission issues based on the, I can't think of anything to it. Or can't think of issues for, so I'd say a memo.
Okay, and what was the second date that we had in September?
23rd.
I would move that we have a subsequent hearing on the 23rd, as it relates to the outstanding pending motions, which can then be heard before we actually have the hearing.
So that, you got a motion in a second, so you can, and then, I don't
Thank you. Yes, Mr. Hicks.
Well, because so that's why there's 3 motions that specifically relate to Alan Freeman. The Pam Freeman motion that kind of sometimes gets interplayed here. We don't have to, it's your guys' commission, but it would be good to have a little discussion of that one because I think it will be informative to the commission on what my position is on that affidavit because of an entirely different set of situations than the Alan Freeman affidavit.
We've seen your motion. I have to tell you, if I'm inclined, I would be asking this commission to dismiss that. But yep.
Yeah.
But I seek to question Pam Freeman on her communications with people, with Megan Fitzmartin and people that were not her spouse.
yeah, okay.
So I'm not asking for her to examine her on communication with her spouse. I'm asking her to examine her on emails that she had with Megan Fitzmartin and people who were not her spouse.
Right. So spousal privilege is not just about communications with your spouse, it's about communications that may incriminate your spouse.
And it's also not a blanket thing, so you can't, and then she has to make those choices, but again, my, wanting to question her, I know we're not gonna hear this today, but the point is, I just want to not lose that my reason for wanting to question Pam Freeman has nothing to do with any communication with her husband. It has to do with communication with other parties, and if she wants to assert the fence, she can assert the fence.
Is the desire to argue the campaign motion today or later?
Later.
Well, then I say,
together.
you don't want to hear my elephant crows respond.
We just.
No, we heard it.
We have not, the motion is still pending before.
The amended motion.
The amended motion. Is
You write that down,
And
Catherine.
it has been seconded.
has been seconded.
The amended motion was that
We
the,
hold all the issues
That
that
all-
we're meeting here in advance,
Yeah.
at a later date, that the parties will provide memos to the director within 2 weeks. That a subsequent hearing on the 23rd will be held to determine outstanding issues, but it is appropriate to say there will be other things coming in along with the ones that have been here And that right now we are scheduled to have a full hearing on this matter on October 7th.
So I believe Mr. Norman didn't say 2 weeks, he said August 26th.
I did say that, which is the date of our next hearing.
Which is the,
Would you also reopen the exhibit windows? We've already filed exhibits on August 11th. Or wait, or you can take that matter up later when we get to these.
Right.
Things like that.
If there's a motion.
Right.
And confirming the second. Other than the motion stated. Yes.
I heard that earlier.
Thank you very
I
much.
did as well.
So, any more questions, comment on the motion? All in favor?
Aye.
Motion passes.
6-0. There you go. There we go.
Thank you both.
Thank you.
Let's get Mr.
Okay.
Karen.
Frank, to you quickly. You only got a 10-minute burn, right?
I'm good.
You did say Grove City.
You gotta get it smart, I want to get out of the garage, get out of the
Over down there, that.
That's 15 minutes. And then a party.
Maybe you got everyone else. I did. Which
Next
is
time I
another-
go down 71. I'm dead.
Max it down there on the.
What's the corner? I will, sir.
I denied that to your point.
Oh, I didn't.
But I might go there.
All right.
It's equal.
It is a good TJ.
All right, we're back. We're back. We're back. Okay. We're on to item 5 of the business. We're on to item 5 of other business. Okay. Next meeting on August 26th. An issue I wanted to bring up, just came up this morning, and I passed along to Phil on that, I didn't get a chance to take a look at it. It's come to, our attention, at least a couple of board members that, there may be an option to allow the board to remain virtual for at least several more months. And I know when you and I chatted about that, just during one of the breaks, you indicated you were not aware of that. Totally aware. Yeah, could you take a look at that and let us know if you get an email on it?
I,
Not that will change, but I think the board needs to be fully informed.
yes, I had a motion on the agenda as well, which, not to reinvent the wheel, most of what was said previously, it was a motion of Fosh,
Do I need to step
Dean
out?
Schmidt, so you were recused on it.
Yeah, I am going to step out, sorry.
And at least I understood that from the bird, so that's why I stood up in this area. And I know is, involved in that, at least, well, when Christ leaves, I say. Part of which, if I can proceed, it will be moved, because what we did here, Gene Schmidt, who you found probable cause presumably, based on his insufficient affidavit previously, is now a respondent as a hearing is sort of scheduled. And he has subpoenaed her with the same kind of factual allegations to the the Alan Freeman hearing, which is on August 26th, filed a motion to quash. It has now been continued, if I understood, to October 7th, presuming he will reissue a subpoena for Ms. Schmidt. I think the same issue and argument that was raised with regard to Freeman applies in her case, and she's a respondent. She was subpoenaed to testify in overlapping issues where it's a claim of in-kind contribution by ORP resources and a claim of improper reporting. I don't see how she can be compelled to answer Mr. Norman. She did not file an affidavit in response. Counsel appeared on her behalf, so I don't think there's a waiver issue, which you discussed. And I did raise in the motion as well. I don't think you're serving your subpoenas if you're going to try and compel attendance properly. You know, attender of both witness fees and mileage is required by Civil Rule 45, Criminal Rule 17, 10142, which you incorporate in your OAC rules, say you will do your subpoenas in accordance with how courts do them. That's how courts do them. So I know Mr. Richter in my conversation with him said, we don't do it that way, but at least your rules say you're going to follow civil rules and criminal rules, and that's what it's required. So if you have a witness who does not want to testify, and you're not properly serving them, when you go, or the Attorney General goes to the common police court to try and enforce it, you don't have proper service.
And in fact, I think that what that previous argument was about, I don't know if there's proper service on any of the parties yet, but at least I know there was proper service on this Schmidt. And so that was the second basis for the motion to quash. I'm happy to have that reserved and file something with Mr. Richter, for commission consideration, because obviously she isn't going to be compelled to appear on August 26th because there's no hearing bringing the case on the 26th.
Yes, please.
And I suppose maybe this is a discussion to have when Mr. Kreitz returns to the room, but maybe what we should work on establishing is a change in our rules that anybody who wants to issue a subpoena is going to have to figure out the mileage and the fees to issue that subpoena as opposed to our commission, because I certainly know it's not on our budget.
Well, yeah, but see, I mean, we've issued the subpoenas this way for as long as we have, and certainly there are cross references to 10142, which is essentially the General Assembly's subpoena provisions on which we operate. But
So my suggestion would be that we also take that up on our August,
August 26th?
August 26th, that week when all those rules are submitted, materials are submitted. That we can rule on it. We're gonna have to rule on that before then, because you won't be able to get things out in time. Wait until 2 weeks before probably. Pretty close.
what we talked about the September 23rd as the hearing on certain issues. You're saying this, though, we can decide on the 26th.
Well, I'm saying we maybe have to have information on it by the 26th and then set it for a decision before that, so that they are, but, this issue. I mean, that's a short window to get us an issue, so.
I don't disagree. What I was about to say though is the issuance of commission subpoena, the commission may issue a subpoena, any person is paid, compelled, and follow along the law. The fees and mileage of the sheriff and subpoena witnesses shall be the same as that allowed before common police in Frank County. Fees and mileage shall be paid in the same manner as other expenses of the commission are paid. In order to receive payment for fees and mileage, a subpoena witness must submit an application on form which may be obtained from commission staff. Our rules lay out how we go about sending out subpoenas and the manner in which we are. So I've been following our rules in terms of how we send out subpoenas. I appreciate both for Mr. O'Brien and Mr. Fry's arguments as it relates to giving them attendance fees and all that kind of stuff. That's not what our rules obligate us to do.
Right, so the legal question is, can our rules trump the civil rules and the criminal rules?
I believe, considering we need to vote the civil rules, that they don't conflict with our rules. My argument would at least be that ours apply, because we have the ability to write our own rules, and we have, where we get our subpoena authority.
I would argue that any ambiguity is going to be construed against the drafter of the rules, and if we're applying the civil rules and we have two rules that are not congruent, if somebody doesn't appear to pursue for that subpoena, I think they have the strong argument saying, look, you said follow the civil rules.
Well, I just think it's something that the commission should address. I'm not saying it's in this moment, because it's been a long day, people have limitations. So we either need to set that or have the parties brief it, Mr. O'Brien has.
Now, I'm happy to provide some additional information. My issue is service, not payment, which is that caused me, at least I.
So
I'd like to be able to respond to somebody. He's talking twice now.
My suggestion would be that whatever, any information on that be submitted also by the same date,
August 26th.
August 26th. And we can take that up.
Okay, I just want to respond to a few things because I don't want to.
Well, I would say no in this instance, because
Well, he made representations that were false. And so I just need 2 minutes to just set the record straight.
it's not,
hold on,
it's not true, and it's not factual.
Okay, well, what I want to question Gene Schmidt on is joint buys of Ed's filmed at her house and her sister's house. and that how he managed to get a bill from Constant Content and Pad and Alan Freeman did it. Very different issues than what he made it sound like the issues that I wanted to question Gene Schmidt on were the same issues as in the affidavit around Gene Schmidt. They're very different issues. Because remember, the ads, the media buys were done jointly for Gene Schmidt, so she's on the same invoices. So that's what I want to question her about, not about stuff that was in the other affidavit. So I apologize for getting you to gavel me, but I think it's very important that people here separate and don't let these guys conflate things that are not conflated.
But you'll have a chance to address that.
Yeah, but we got a chance to address it now and plant the seeds in your heads, and I deserve the right to plant, correct the record.
All right, I'm gonna bring this back.
Thank you.
We're done with it?
Thank you.
Thank you very much.
Just while he is reassuming the seat, and actually, I had a couple of conversations with Mr. O'Brien, because he's on the liquor control commission. And, you know, he was kind of getting a little conversation about the meetings, and they were anticipating continuing to meet remotely. And the fact that it's beneficial to them, because, you know, although he said of the 3 members, one in St. Clairsville, the other 2 are local, that one in St. Clairsville would be beneficial. But he said they're bringing in liquor control agents from all over the state, and they're now obligated to come back here. And he was saying they're looking at, or they are having their meetings here in Columbus again. It was my understanding that as the state budget did not extend the ability to do so beyond June 30, that we're meeting here. So I'll gladly look into it, because as I said, a year ago, I was as skeptical as anybody, and I was saying, no, we gotta have these meetings in person. I'm more than willing to, you know, to try and look into it, but that is the first I've heard of that, and everything comes back from the governor's office too, and you're back in person, everybody here. So, okay, anyway,
That's all we can do is ask you to look into it.
I will gladly look into it. I'm not sure where that came from, but, you know.
Well, this morning we were talking about, all the agencies returning back to the office, and I had mentioned where, they were doing 3 phases, and I said they were releasing people back at, you know, different times, and I said, but it's up to the agency itself. As far as when you come back, I said, technically, we weren't supposed to come back until like phase 3, but these 2 of us in the office, slow impact on the building, and, you
I
know.
think that's just on personnel
Yeah.
in the agency, and not as it relates to the meetings of the groups, boards, and commissions. If
That makes sense.
So, that's fine. I'll just take, but that's everything I've heard.
Some of us who have to travel, I hope you can do it remotely.
Yeah, I do too.
I think it's passive.
I don't think I'm all the way from Arlington.
Well, you know what I've experienced is,
Yeah.
today or not, nobody shows up, but before.
People have bills
You're in weather day,
More people involved.
Robert's state reach.
Right.
Like I said, I'm a convert. I
like people getting their say.
I liked it as well,
I
but,
do like that.
but, you know, the General Assembly made the decision that it did, so.
I don't mind driving now, but not as far as that.
We've got
But I
it.
could
I don't
get, I
care
could
now
do
that I
fun
know
things like everybody fun.
I got
We
it.
got it done.
But I'll tell you, I think,
That would be nice to have virtual, all except December, because I went to big Christmas.
Yeah.
We are going to match the Christmas party that Mr. Bromer put on for us. I want you to know that. We've got a court order.
Penny for penny, right, sir?
We've got a court order taking all this down. I can move to adjourn.
The chair haven't, came back for that one thing.
Yeah, I wanted to make sure we had a discussion on that.
Okay. Is that your last?
That's it. Okay, is there anything else? Motion to adjourn and a second from Ms. Kaufman. All in favor, signify by saying aye.
Aye.
Thank you. We're adjourned.
Thank you. Good luck.
We're adjourned.
Right on time, 1:30 is what everybody says.
There you go.
Appreciate it.
It's all common.
I did. Oh, yeah. Oh, thank you.
That's fantastic.
Several hours.
You might need to.
Oh, delegation, I want this date.
Nothing blew up. Nothing was blowing up. So, yeah. I could-
I'm now going to do what you want.
Yeah.
I
I know, I was kind of hoping Everything was going okay, so I will follow up and make sure.
Oh, we're jumping to that.
Whatsoever.
What's the bill that cites as, those funds on? Is there somebody we can give that to cite the, I don't think maybe it should be used.
I don't know, I wonder if.
Like,
the
like told me they're gonna ask them before the end of the year, and they've got,
I'll continue to